My administration is issuing new federal guidelines that will allow governors to take a phased and deliberate approach to reopening their individual states.
And the governors I have given them great discretion. I respect the governors, and I've given them great discretion.
I would strongly say they should open. It's up to the governors.
As the coronavirus remains a threat, President Trump is insisting states should be in charge of making their own lockdowns. But some governors are now facing legal challenges. One of the most recent examples comes from Wisconsin. The state's conservative-dominated Supreme Court struck down the stay-at-home order put in place by Democratic Governor Tony Evers. The court says Evers should have worked with the legislature on the rule. To date, it's the only successful legal challenge to governor's lockdown rule, but others are in the works. As Kim Wehle argues in Politico, the hodgepodge of state regulations is jeopardizing the nation's health. She says the Trump administration should enact a national quarantine, which she believes is both constitutional and necessary. CBS News legal analyst Kim Wehle joins me now from Chevy Chase, Maryland. She's a constitutional law expert and a visiting professor and fellow at the American University Washington College of Law. Kim, thank you so much for joining us. When you look at this, what powers does the Constitution really give the president to enact a national quarantine?
Well, the power actually belongs to Congress, and Congress authorized the president through a statute called the Public Health Services Act to implement national quarantines if it's in the public interest. So the president himself has limited power under the Constitution, except as what's given from Congress. But remember, one of the primary reasons for having a single person in the White House is to respond to emergencies, typically military emergencies. But that's a justification for a lot of power in the White House, swift, nimble reactions to crises. And we're just not seeing it exercised in this moment.
You know, a number of these state cases say that the government is actually infringing on the freedom of movement, which, as you note, is covered under several amendments. Based on your interpretation of the Constitution, why is the federal government allowed to sort of infringe upon these rights during a pandemic?
Yeah, so the federal government and states infringe on our rights a lot. When I say our rights, we have the Bill of Rights, First Amendment free speech, for example, but you cannot shout fire in a crowded theater because there's a public interest that is a counterweight to individual rights. Same thing, you can't have plutonium in your garage, even if that is a weapon under the Second Amendment. There are limits on all kinds of our rights. And in this instance, it would be our right to not wear a mask, our right to walk into a private facility, a store without that kind of precaution, our right to leave at will in our homes. That is the counterweight there is the interest in the public in maintaining public safety and tamping down this pandemic. And this is a balancing act. And I think it comes as a surprise to a lot of people that a lot of the Constitution comes down to a balancing act. And I think in this moment, based on a case that goes back to 1905, the Supreme Court could hold, if challenged, that if the challenge were to reach the Supreme Court, that the government can impose these kinds of safety measures for the benefit of the populace as a whole, even though our individual rights are temporarily restrained.
Kim, I also want to ask you particularly about voting. President Trump is threatening to actually pull funding from Nevada and Michigan for their efforts to push mail-in voting. In Texas, the state attorney general is also appealing a decision to let all citizens apply for an absentee ballot. Does the Constitution specify what federal government can do about an election in a time of crisis like a pandemic?
So the Constitution gives most of the power over elections to the states. Even though the right to vote is really at the heart of our democracy, the framers couldn't decide on a system. So the states individually can implement their voting processes as they wish. The Constitution does give Congress the power to come in and implement national rules. For example, you could go, when you register for your license, your driver's license, you can register to vote because there's a statute, federal statute that authorizes that. There is no power lodged in the office of the presidency to control voting. I know the president mentioned something about withholding money, but the appropriations clause of Article 1 actually gives that power to Congress. So Congress could come in and say, like they did in one of the COVID bills, here's money to the states to implement elections in a way that takes into account COVID, and that's mail-in voting, for example. Congress could authorize mandatory mail-in voting, for example. But I don't think the president has any power in this instance to make it harder for people to vote. And I should just note empirically, there is a real debate about voter fraud versus efforts to make it harder to vote. The empirical evidence on voter fraud is infinitesimal. It's virtually non-existent. So I think most people who've looked at this issue from a legal standpoint would say the right to be able to choose our own leaders is, again, on a balancing act, far outweighs the concern that one person might vote fraudulently, and not be able to even influence the election if they did vote fraudulently.
Kim Wehle, I want to thank you very much for joining us.
Thank you, Reena.
You bet. And by the way, you can read more about voting in Kim's new book, What You Need to Know About Voting and Why. It'll be released June 16th.